Hello, Your Honor. How are you?
I'm good. How are you?
I'm fine, thank you. It's very nice to see you. And it's very nice of you to take the time, despite the fact that you're very busy in court, to actually help us start the year with some tips and on best practices for lawyers. So that's very nice of you to do. And I will let you introduce yourself for those who don't know who you are. And then maybe if you can tell us what your best advocacy tips are.
Of course. Well, thank you for having me. I think this is a great idea, and I hope it's helpful to everyone. My name is Justice Brock Jones. I'm a judge of the Ontario Court of Justice. Prior to that, I was a Crown Attorney for about 16 years. And I became a judge, I guess, in the midst of the pandemic. And I know that that has caused a lot of havoc in the profession. And now that we're hopefully, fully out, or at least largely out of the pandemic, and there's a lot more going on back in person in the courts, at least in Toronto, and I suspect in other parts of the country and the province too. I've just noticed a few things, and I think it might be helpful to remind counsel, particularly younger lawyers, about what are the best ways to present themselves in court. What are some of the pitfalls they can avoid? And what is different sometimes about doing something in person as opposed to doing it over Zoom, right? Because we've all become very used to Zoom proceedings. I know for a long time that was almost the only thing many people did. And for many young lawyers, that's how they started their careers. But now that we're all coming back into the courtrooms and doing things in person again, I hope I can provide some helpful guidance and some basic tips to people about how to make the most of those in-court appearances, whether it's a guilty plea, whether it's a trial, whether it's something else, so that you do the best job possible for your clients, so that the court hopefully gets the best advocacy and the best information that we need. And also, if you're a Crown Attorney, I've got some suggestions as well about how to make things move as smoothly as possible. So I've got sort of a list of things to go through, but please don't be afraid to interject as we go along if you've
Yeah.
got an observation or a question. I hope this is helpful to people, particularly people who haven't had a lot of experience doing in-person matters yet, and are hoping to get better at it, hoping to learn. So some of these will seem a little basic, but don't underestimate the importance of the fundamentals. Okay, so I'm just going to start with what I think is the best one to begin with, which may seem obvious, but is not to be underestimated. So the first fundamental tip is just please come to court on time and please be prepared. That
Yeah.
may seem very basic, but it is still extremely important. When I go into a court in the Ontario Court of Justice, right, particularly if it's a plea court, but even often if it's a trial court where the lists can still be long, knowing that the lawyers are ready when I go in there, knowing that they understand the case, that if you're defense counsel, you've gotten instructions from your client, that if you're the Crown, at least you know if your witnesses are there and if you're ready to go or not. Just that you'll impress me that you're prepared and you've come in and taken it seriously. It makes a world of difference because I will have almost inevitably multiple matters on my list. Some of those matters are going to be more challenging than others. If the accused person is in custody, for example, it can often be difficult in Toronto even getting them on the screen if they're still at the Toronto South Detention Center, or if they're supposed to be physically in the building. Sometimes there have been hurdles with having that happen smoothly. And then, of course, there's also always the fact that there may be self-represented parties in the courtroom for a trial or something else. And I'm going to have to help them in particular quite a bit. So knowing that the lawyers have come in at least and they understand their case well and that they are prepared, whatever's going to happen, whether it's going to be a trial, whether it's going to resolve, or maybe the Crown's just going to withdraw for whatever reason that day. What can sometimes be, I guess, disappointing is that people come in late or they say, well, we need more time to have these discussions between ourselves. Or perhaps your defense counsel, well, I haven't had a chance to speak to my client in several weeks. I need some time, Your Honor, please, just to have a private moment with them to get updated instructions or whatnot. Now, I'm a realist. I know that you can't control your clients and the Crown can't control how witnesses cooperate or not. And some of this is going to be inevitable. But if you can just minimize it to the extent possible, so that if I come in and we're ready to go, and there's only so much time in a court day, that we can maximize that court time as best as possible. And I can guarantee you this, if you have a reputation for always being on time and prepared, that will do wonders for you. Okay, I can assure you it will never be anything but incredibly positive for the development of your career because we're going to see each other a lot, and that's exactly the kind of impression you want to make. So what do you think of the first one, Maya? Is that a good start?
Yeah, it is. And I mean, I have to say that after Zoom, it's been more difficult for me to be on time. I used to always be on time, but after Zoom, because I got used to, like having more time to appear, it's been a challenge. So it is very important to remember that being on time is really very important for everyone, especially in busy courtrooms.
And things happen. I understand that. There could be a
Yeah.
traffic problem. You might have a childcare issue that morning. We're all human. These things can occur. If you know you're going to be delayed, do your best to send a message if possible. Maybe the crown attorney is already there. Maybe there's somebody else you can pass it on to, but just don't sort of leave us wondering what's happening or where you
Yeah.
are, what's going to go on. Or worse, have your client show up and say, I don't know where my lawyer is, Your Honor. I don't know
Yeah.
what to do. That's just not a good way to start. Okay. But that one's basic. But here's another basic one, number two, that
Hmm.
I also want to keep everyone focused on, as I think it really is just fundamentally important. And that's that you always treat everyone in the courtroom, and I mean everyone, with courtesy and respect. Obviously, you're going to focus, I'm sure, on not offending the judge and wanting to come in and make a good impression in that regard. Certainly appreciated, but I can take it. Okay. More important to me often is that I see that the lawyers are treating the staff respectfully and everyone else who assists on a day-to-day basis with running the courts properly. If there's an interpreter, the correctional officers who often have a very difficult job having to manage bringing inmates in and out from the institutions and up. Of course, any witnesses who might be there or other parties for other proceedings, and opposing counsel as well. I know that things can become heated. I know that sometimes it's frustrating and you may wonder why this even had to get to the point that it's at. Uh, but I cannot emphasize the importance of this enough either. We all have to get along. We all have to work together. And if your reputation is developed as someone who just isn't unsettled easily, who doesn't get angry easily, who can handle even maybe the most frustrating experience with a little bit of grace and a smile, that again is such a testament to your character, and it's going to go a long way. And it's going to make me feel that every time I see a particular lawyer, I want to work with that person because I know that they're always going to come in there and treat everybody the way they should be treated. And obviously, that goes for my colleagues as well. We should be treating everyone properly in the courtroom as well. And I hope I haven't lost sight of that. But it's so important that we all strive. We all reach for the brass ring in that regard. Because if we don't, it's easy for the profession, unfortunately, to become unpleasant and in an unnecessary way that just makes proceedings more difficult for everyone. So please do your best to come in, even if you don't want to be there, even if you don't think your client should be there, whatever it is. I guarantee you the day will go better if we can all just sort of keep that fundamental value and perspective in mind.
But I do have a question here on this point,
Yes.
because sometimes, even when with all the best intentions in the world, we all want to be positive and we want to be civil and nice. There are sometimes people, I don't know, maybe they're having a bad day, they're just grumpy people. And how do you, like, what advice would you give for lawyers, especially new ones who don't have a lot of court experience? How do they deal with that? Because sometimes people do make comments, they're nasty,
Hmm.
they're offensive. And for new lawyers, especially, how do they react in a way that they don't lose their temper and they still remain civil?
Right. No, and unfortunately, there's been a long and disappointing history sometimes of bullying in the profession, particularly from sometimes more experienced lawyers who I guess are testing to see if they can push younger counsel around. It shouldn't happen. It's really inappropriate. If I see it, I'm going to remember it and not in a positive way for the person who's doing it. What I would say is this: if you're frustrated, if you feel that you've been mistreated, if you're really disappointed, perhaps that no one's listening to you or taking your point seriously that you're trying to make and you're just being disrespected in that regard, it's never inappropriate to ask for some time just to cool your jets, to think through how you're going to handle it strategically. I would always suggest people look to mentors or friends that they can reach out to in those moments. But the way not to handle it is to let something slip in the courtroom that may not reflect your true character at all. It's just a bad moment in a bad case. But I may only see you once in a while, and that may be unfortunately what I remember, if it happens in the courtroom or not. So, I mean, I know it's difficult. We're all human, and we have to balance ourselves as best we can. But I do strongly encourage everyone to not succumb as much
Yeah.
as you can. But at the same time, if you're a more experienced member of the profession listening to this, there is nothing more unseemly to me than seeing somebody talking down to somebody else. Like, we have to encourage new lawyers. We have to give them the training that they need. We have to want them to be a part of this profession so that it succeeds and it grows in the future. And the way not to do that, obviously, is to treat people poorly simply because they may lack experience, or may have taken a position on a matter that somebody else doesn't think is reasonable. We'll sort that out at the end of the day, one way or another. If it has to be through a hearing in front of me or another judge, so be it. but it should always be done civilly, hopefully, and respect.
Thank you.
Okay, the third tip I want to bring, a little more substantive now, we're going to move along, is this. I'm sure when you come to criminal court, you're prepared in sort of a more abstract sense or broad sense for what the case is about. You know your client is charged with assault. You know basically what the Crown's case is. You know what you anticipate the witness might say. You know how you think you're going to defend the matter. Okay, that's fine. Or if you're the prosecutor, again, you think, okay, well, I'm expecting Mrs. Smith to show up. I'm hoping Mrs. Smith says the following things. And if she doesn't, how am I going to proceed? And I basically understand how I'm going to try to prove my case. Something that I'm sometimes surprised at is that it doesn't appear that anyone's actually read the charging document very carefully before the trial starts. Like you may understand that your client is charged with assault, but have you actually looked at the information and in Toronto, the digital information to see exactly how the charge is worded? This is very important. Sometimes there are flaws with how charges are drafted. It's particularly important for Crowns to catch this ahead of time. Sometimes there are other problems with the charges. For example, I've seen informations where someone is charged with the exact same count multiple times, and that offends one of the rules about pleadings, at least in this province, based on a lower case from our Court of Appeal. And it just doesn't appear to me that anyone has really taken a close look at the charging document until the trial's about to start. Sometimes, quite frankly, not until the arraignment happens and they hear the clerk reading it out. And then I get these funny looks from people sometimes as they're actually hearing for the first time exactly how the charge has been drafted. So if you're the Crown, really want to review that ahead of time, A, to get out of an embarrassing situation where you're asking me to amend it, perhaps on the spot, not realizing that that's how it was drafted in the first place, when really you should have realized that ahead of time because it's your prosecution. But if you're defense counsel, this can often be a way sometimes to find strategic advantage or to be ready to, I don't know if I'd say lay a trap for the Crown, or at least let the Crown walk into a trap of its own creation because it didn't fix the information ahead of time. And there are often little things in those charges that if you pay attention to can be pivotal in some cases. And if you're the prosecutor and then you realize it and you have to ask for an adjournment on the day of the trial, for example, this can just result in unnecessary delay. Because if defense counsel convinces me, well, wait a minute, if the Crown's amending the charge now, and this is going to cause prejudice to my client's ability to defend him or herself, or how we've planned for the trial today, then that could be a basis for an adjournment. Possibly. It'll depend on the circumstances, right? But again, it's a problem that can and should be avoided. You should get a copy of the charging document in your disclosure materials, I would hope, at least how it's initially drafted by the police. But you have an absolute right to review that charging document before the trial and at the trial. And if you haven't seen it and you want to know exactly what's on there and how the charges are drafted, in my view, that's clearly first party disclosure and it should be handed over just with a simple request, either to the court if you need to get it from us or if the Crown's office has it, for a request through them. But just read it carefully. Don't underestimate sometimes the sloppy drafting of these charges that can happen. And even if it's going to be a guilty plea, you should probably take a look at it ahead of time to know, well, what counts specifically? Are they drafted in a way that I accept, that my client can accept? And is there anything in there that should be worked out ahead of time?
And the
I've seen,
election as well. Like,
oh,
especially if
absolutely.
there's a guilty plea, if it's by
Yes.
indictment, if you want it to be done summarily. So those are also important things to,
Yes. And sometimes there's a replacement information. I've had cases go on
yeah.
where the lawyers are surprised. Well, there's four informations in court
Yeah.
today, and nobody thought that. And you've got to start parsing out, well, which one is which. And that's fine. That's going to happen. It just shouldn't be happening on the day you think the trial's going to happen or the guilty plea is going to happen. It's just wasted time. Again, it's unsettling. It can be embarrassing. And, you never know. You could get a grumpy judge really for no reason other than the fact that this wasn't dealt with ahead of time.
Mhm.
So I encourage everyone to really carefully examine those charging documents before the rubber hits the road in court, so to speak.
All right.
Okay, another sort of quasi-substantive tip, maybe a little more procedural, is obviously a great deal of evidence in our cases now is digital, right? In some form or another. You're going to get videos, you're going to get pictures, you're going to get social media evidence. You may produce that on your own as defense counsel. Maybe your client has given you something, or maybe you hope you have something, to catch a witness by surprise in court. All of this can be excellent and very persuasive. What is not excellent is when you come in and you go, "Oh, sorry, Your Honor, I don't know how to play this in the courtroom," or the video machine isn't working for me, or I can't get it to play on Zoom properly, or whatever it may be. There's really no answer to this, unfortunately, other than testing the technology ahead of time. So if you know you're going to want to play videos, other forms of social media evidence, an audio file, whatever it is that you want to use and get the maximum value out of it, either for your defense or if you're the prosecution, you're going to lead the senior case in chief, that's great, that's fine. But you really should be in there figuring out, well, do I need an HDMI cable? Do I have the right kind of laptop? Can I connect to the Wi-Fi in this courthouse or not? Like whatever it is, you want to make sure that's done ahead of time. Because if you can come in there and you're just ready to start, and you can say to me, look, I'm going to play this video now for the witness. I've got it queued up to the right time. You know, it's the body-worn camera footage of Officer Brown. It's at time 15, 25, and 36 seconds or whatever it is, and you're going to step me through it. Believe me, I'm noticing this. I'm noticing how prepared you are, that you've got the technology working, that you know what you want to do, and you know exactly where it is. Versus, unfortunately, you know, you're kind of fumbling around going, oh, well, I can't get it to work. Or maybe you ask the other lawyer, can you help me, please? And it just starts to seem like, you know, the wheels are coming off, and not on a substantive level. Not because you don't have a good strategy or know how you want to run your case, but simply because you can't get the bloody video to work properly and you didn't have time to figure it out beforehand. So again, I would encourage you to come in a bit early if you can. If you know in Toronto, the trial court's open at 10, consider coming in a little bit earlier, talk to the staff, say, look, I want to do a dry run here. Can you help me? Can I see if I can play my videos properly? Can I do whatever? Hopefully that's helpful. You know, if the staff tell me at 10, look, the lawyers are ready to go, but they're just trying to work out the technological snafus right now, that's fine. I'm happy to hear that you're working on it. I prefer us to start at 10, but if you need a bit more time, that's okay. As opposed to we're in the middle of a witness testifying and then suddenly everything falls apart because, you know, you didn't take that time earlier. And it is not because I am some technological master and I'm sitting up there laughing at you as you can't do it. Far from it. I remember the pain of being in your position, and I don't think I would be any better at it, but it's still your obligation to be prepared, right? And to try to do this as smoothly as possible. And you don't want to lose court time or have something go wrong when it was probably something that was preventable up front. Now, I don't know if you're seeing different forms of digital evidence that are particularly frustrating to get to work, but I do find the body-worn camera footage and getting it to play properly has been a recurring challenge for lawyers, at least in Toronto.
Yeah, and I mean, sometimes we do the tests beforehand, but unfortunately, on the day of, it just doesn't work. And it's unfortunate when that happens. Um, so, I mean, I think still the best thing to do is to try to test that in the morning, on the morning off, before the proceeding starts. It always helps. But I mean, with technology, it's a little bit tricky though, because I still find that there's always something that happens out of nowhere, or like that's unfortunate. But in order to avoid that, I guess the best thing to do is, like you mentioned, it's just to prepare and try and test it before we actually start, as opposed to during the proceeding.
You know, and talk to the Crown's office too. It may be advantageous for the two of you to get together and just explore or try some of these things.
Yeah.
For example, if you want to have a, you know, a witness testify from a child-friendly room in the courthouse or something to that effect, all completely understandable. But don't underestimate the value of just trying that ahead of time. Maybe lining up who might be able to help you ahead of time in the courthouse. Maybe there's somebody there who's tasked with making sure the technology works properly. Just knowing who to contact if there's a problem. Ask more experienced counsel, just try your best to be ready for it. Because the worst moment is when it doesn't work and then someone says to me, well, Your Honor, what do you propose? I mean, man, if I ever have to bite my tongue, it's at a moment like that, believe me.
Yeah.
The answer is I would propose you came in here prepared
Yeah.
because I'm not responsible for trying to help at the last second there. Anyway,
Yeah.
just a suggestion. I understand how difficult this can be. I don't mean to make light of that. And you're a lawyer. You're not meant to be a tech expert. But unfortunately, you're going to have to at least get up to speed in some regard with respect to some of this technology ahead of time so that we don't lose valuable court time just for this sort of, you know, hopefully preventable, you know, matter.
Yes.
Okay, let me shift now to another topic. It's similar to something that I mentioned earlier, but it is something I want to focus on just a little bit harder. Okay, so a much wiser judge than me once remarked that a trial is not a tea party. But to that, I would simply add it shouldn't be open warfare either. And earlier, I mentioned the importance of being respectful to everyone in the courtroom, including opposing counsel. I just want to focus on that a little bit more right now. You know, there's a reason, I hope, why the legal profession has so many awards for civility. Okay, this matters a lot.
Mhm.
And being hostile to the opposing lawyer. Oh, I'm sorry, the lights in my office just went off. Isn't that
Yeah.
hilarious? Um, Being hostile to the opposing lawyer is not going to get you better results, at least not in a trial, not in front of me. Okay. Again, it does make everything more difficult. You can advocate passionately. You can defend your client passionately. You can fight the case passionately. If you're the prosecutor, you can mount a fair and vigorous prosecution fairly. Okay. But it doesn't have to get to the point when I can feel the tension in the room or I can see how much people dislike one another. I understand sometimes, especially your defense counsel, you may just not understand why wouldn't the Crown take a different position here? Why did it ever have to get to this point? Conversely, if you're the Crown and you strongly believe in your case, you may wonder, this is overwhelming evidence. They're just playing witness roulette to see who shows up today or not. This is outrageous, etc. Right? And tempers can get a little heated, and sometimes differences about how a case should be resolved or what the sentence might be are going to be strong. I understand that. But all that being said, I just want to step people through a couple of important cases that I think the Supreme Court has made in the last few years that should just focus people on what they can and can't do, or what they should and shouldn't do, maybe is a better way of phrasing that. So, in general, okay, please do avoid, and I know this seems obvious, but I do feel sometimes people slip into this almost in the heat of the moment, and they probably regret it, but it happens. Avoid repetitive, kind of personal attacks at any time. Never use demeaning or sarcastic language. I've had objections sometimes where counsel will say, well, apparently my friend has forgotten about the importance of X or Y. And it's just kind of laced with this undertone, of disrespect. It really doesn't impress me. And I can't imagine it does any judge. Again, it's unnecessary. Those who can rise above, the temptations, the pettiness, and just always do things in a professional manner make such a better impression. Um, Always advance the position that at least you can make in good faith and on a reasonable basis. There's nothing wrong with challenging the case for the other side, with not agreeing with what the other lawyer takes as a position. Obviously, all of that's completely legitimate. But don't ever do something just because you think you can. But when in your own heart, I really don't have any good faith basis to make this argument, but I'm just going to do it to see maybe if I can get away with it. That kind of thing can be very dangerous. Even if you're defense counsel, I know your primary goal, really your ethical duty is to defend your client to the limits of the law. There's an excellent case from the Supreme Court, and younger lawyers may have missed this. It was very, very popular and well known when it first came out, called Groya and the Law Society of Upper Canada, 2018 SCC 27. This involved a very well known lawyer who did not care for how a certain case was being conducted, to put it mildly. And the Supreme Court of Canada talks about the role of civility in the profession and the jurisdiction of law societies, to govern their members for remarks and for conduct that is obviously outside the scope of professional conduct. And it's just a good read about, what can and can't be done, and really, how far you can push, in being a strong advocate without crossing that line. If you're a Crown, I highly encourage you to read a recent decision from the Supreme Court of Canada about the role of the Crown. Never forget that the Crown's role is so unique, okay, in our legal system. As Crown Counsel, you are fundamentally a minister of justice. You are not there simply to win, and certainly not to win at all costs. And the case is called Kasai, Kahsai. It's 2023 SCC 20. And in that decision, the Supreme Court again comments on the role of the Crown and builds on a lot of prior jurisprudence that I would encourage everyone to read there as well. I'm just going to read a paragraph from that decision now because I think it's just vitally important, not only for Crown Counsel to understand this, so they focus on how their job should be done and what their role is, but also, quite frankly, so defense counsel understand what the role of the Crown is. And I hope that that helps foster positive negotiations. So, quote, as local ministers of justice and officers of the court, Crown Counsel have a duty to preserve the fairness of the criminal justice system for all parties, including the accused, victims, and the public. Because of the public and quasi-judicial dimension to the Crown's role, their function is not adversarial or partisan in the traditional sense. Rather, it is driven by their purpose to advance the public interest. As famously expressed by Justice Rand in Boucher and the Queen from 1955, the goal of the Crown is, quote, not to obtain a conviction. It is to lay before a jury what the Crown considers to be credible evidence relevant to what is alleged to be a crown. The Crown must always act fairly, dispassionately, and with integrity both in the courtroom and in all their dealings with the accused. So that's the line, the paragraph from the Supreme Court of Canada. I would just say this, if you're a Crown, you should really read this, breathe it in, and live it every day. Okay, this is what makes an excellent prosecutor. It's not so much that you can be a fierce advocate in the courtroom. That's excellent, and I encourage that, of course. It's that I always know that you are the person who will act fairly, who will consider the rights of everyone, including the accused person, during the proceeding, and will not take positions, I should say, perhaps solely or not exclusively, for strategic advantage or to try to get something that you think you want out of the case. Remember, there's a higher duty there, and it doesn't involve, again, the sort of win at all costs attitude. Now, if you're defense counsel, of course, you can be as fierce an advocate for your client as you want. And your primary goal, really your fundamental goal, is to get the best outcome for the client possible, which is often just the withdrawal of the charges or a not guilty verdict. I understand that. But do remember what you decide versus what the client decides. Okay. And there's a famous case in this province, Felderhoff, and then some progeny from that, about the fact that just because your client says jump doesn't mean you say how high. Okay. The client gets to decide certain things, whether to plead guilty or not, whether to testify or not. You, generally speaking, control the conduct of the litigation, including how you will cross-examine the witnesses and how you will otherwise challenge the Crown's case. I know you have to take instructions. I understand all of that. But don't let yourself be manipulated by maybe a hostile client who is simply asking you to do things that you really don't think are necessary or going to truly advance the defense or get you the result that you think is best, but might be being suggested to you for the wrong reasons or simply because of vindictiveness, right? It's very important. And believe me, lawyers who come into the courtroom who I know believe in this if you're the Crown or if you're defense counsel, know how to make a strong defense or challenge a case properly without descending, into unnecessary tactics or even just time-wasting tactics. It's going to do wonders for your reputation. Believe me. Careers can be built at an early stage very strongly, but a few bad moments, or a bunch of terrible habits that you start picking up that you do consistently, unfortunately, that's going to get around as well. So again, look for mentorship, ask senior counsel. There's so many great sources for ethics and for help with advocacy, but don't lose sight of these sort of fundamental principles and always try again to bring the best of yourself to court every day. I guarantee you it's going to make a difference in the long run. Now, I can hear one of the questions already, which is, well, what do I do if the Crown isn't acting like a minister of justice?
Yeah.
How do I deal with that? Well, we're going to get to that later when we talk about judicial pretrials. But, I can guarantee you that, if you yourself usually act with the best character you can, you will probably get more of that back. Okay. And you're going to have days when you go, oh, I can't believe that this is how it's been. And I can't work with this person very well. It's extremely frustrating. I understand that. Okay. But I hope that those days are less than the days when you can get good outcomes by working with the right people. And, you don't want to walk into the courthouse and just feel that there's a lot of people you don't want to see because you can't stand them and you've had a bunch of bad discussions with them, right? It's just going to make everyone's day so much harder.
But Your Honor, I wanted to ask you, so you said you will be talking about the case when the Crown is being difficult. What about when the judge is being difficult? I mean, you're not obviously one of them. You're always very pleasant and very smiley, but sometimes some judges are difficult and they do give counsel a difficult time, whether it's Crowns or defense lawyers. So what is your advice though on that?
Well, I would say this, everyone should be striving, to be their best person in the courtroom, including my colleagues. I appreciate that some judges maybe have different personalities than others. All I can say is this, for better or for worse, if you come into the courtroom, and you have to have the judge make a decision at the end of the day, whether or not you feel that that judge is treating you perhaps the way you would like to be treated, nothing will be gained by ramping up matters or, increasing the temperature or whatnot. I know it's difficult, believe me. I know some days you might feel that it's unfair how things are going or it wasn't appropriate that I was treated that way. But the best that you can do to simply stand there, act maturely, handle it as best you can, not necessarily, be a punching bag, but just not cross the line in how you respond to it. I can guarantee you, for any judge, it's going to make such an impressive moment for you, and you don't want to, make a mistake and fear that judge every time you see them again. It's just not going to be good. And I hope that we can all bring out the best in one another. And even I may have a bad day here or there, but really, it's not going to do anyone any favors to respond. And ultimately, especially if you're defense counsel, it's not going to help your client. It's just
Yeah.
not. Right. I know it's unfortunate, right? You might feel, oh, it's so unfair that I drew justice so and so, and this is the day I'm having. But you may want to give it back sometimes. You may think you have a clever retort at a moment. Uh, you know, I would always ask yourself, is this really going to help my client at the end of the day? Because that's your fundamental obligation, right?
Yeah.
I hope that's some help.
Yeah. Thank you. So what's our next tip then?
Okay, so let's get back to some more practical matters as
Mm-hmm.
well. Okay, know the rules of the court and the practice directions for the court that you're appearing in. So if you're in the Ontario Court of Justice, where obviously I sit, we have a website, okay? And the rules of the Ontario Court of Justice are online, and all of our practice directions and policies are online as well. And these are going to cover everything in the criminal process, at least in this province, right? From the case management stages to how you file applications to what may be expected in a type of court, a plea court, a specialty court, and ultimately how things should be done at a trial. The rules for the Ontario court, in my view at least, aren't terribly complicated.
Yeah.
Some of the practice directions I know are constantly changing. We have a new one now about Jordan applications, and we have a new one too about the expectations of how cases will proceed at the case management stage that was just brought in the fall of last year. But you need to know about these because when you come into any court, and especially actually more at the beginning of a case, or in the case management stage, you're going to need to be familiar with that because the justice presiding in a court, either a judge or a justice of the peace, may, direct you. Well, are you following the procedure that's out there, the directive that's been issued by the Chief Justice, about how these matters are going to proceed? And if you aren't familiar with that, it's just going to put you in a very awkward position. So I know it can be a little tedious to go through these, but you really do have to do it. And if your case suddenly, say, goes to the Superior Court, maybe it's the first time you have personally gone to Superior Court in a certain jurisdiction, again, you better check the procedures and the practices for that court because they won't necessarily be the same as how matters are conducted in the Ontario Court of Justice. The same way I'm sure you would if you're trying to file an appeal in the Court of Appeal, you need to know the rules of that court and what's expected or not. And if you don't, if you're unfamiliar with that, hey, you can look them up. You can, again, speak to more experienced counsel. You can make inquiries. Often these courts have people you can speak to and ask for help and direction. But you can't ignore the rules and you can't ignore the practice directions just because you find them cumbersome or you haven't had the time to really look at them yet. You are expected to know them and to comply with them. And fairness matters at all times to everyone in the courtroom. So if the rules haven't been complied with, the remedy that results is going to be dependent on the circumstances. But a major factor I'll be thinking about is, well, fairness. A, has the other party been given notice and at least they understand what's happening? And also any potential prejudice, right, to somebody involved in the case. Certainly to an accused person. Are they able to defend themselves the same way or did something go wrong that was unfair to them? But sometimes to the Crown as well. You can't just show up and surprise somebody with an application that should have been brought 60 days ahead of time, 30 days ahead of time, and just show up on the day of the trial and go, surprise. I want to argue a charter motion now as well, and I didn't give the court or the Crown any notice. That could easily be summarily dismissed for lack of compliance with the rules, or at least would result in an adjournment, with probably a scowl at a minimum from the judge about why you were not following the rules properly.
Yeah.
And if you just didn't even know about those rules and that becomes apparent to me, that just seems very unprofessional. I will say this, on rare occasion, I have had strikingly honest lawyers come in there and tell me, well, I didn't know about that rule, or I didn't know about that practice direction. And sometimes it slides into the, well, I'm so busy, it's hard to keep up with all this. I appreciate that. I do. Okay. But it's no excuse for not knowing the rules. And telling me that you didn't know them or you didn't bother to look at them or, geez, I'm just so busy, Your Honor, it's hard to keep up with all these requirements of your court, you know, what kind of impression do you think that's leaving me with, right? I may give you the adjournment at the end of the day because I'm more interested in having a fair trial on the merits for everyone involved. If it's not today, then it's some date in the future. But sometimes, the Crown has an interest in moving cases ahead too. And Jordan tells us all we have to move matters ahead within a reasonable period of time, and we can't tolerate, needless delay. And if the trial date has been set and you've had months and months and months to prepare, And then you show up on the day of and go, oh, geez, I just don't have my charter application perfected, or I don't have this done or that done. You know, don't assume you're going to get an adjournment for that.
Yeah.
Don't assume it. That's a dangerous game to play. And ultimately, again, if you're defense counsel, you're running the risk of your client losing a potential defense or way to challenge the Crown's case or what have you. And if you're the Crown and you show up on the day of, you go, well, I really wish I'd filed that similar fact evidence application 30 days ago, but golly, I'm just so busy with all my cases. That's really not going to fly with me, at least. I don't know some of my
Well,
colleagues.
yeah, I mean, that's the thing. I find sometimes the issues that we see with crowns is there's sometimes last minute changes. Like there's someone who's supposed to be the assigned
Yep.
crown, and then there's
Uh,
someone on the day off who's in there and who doesn't know what happened before. That's also frustrating from a defense perspective because we have that crown that we were dealing with and who knows the case. Then all of a sudden we have to deal with someone new
yes.
who's not up to speed. And so that
Yes.
could cause frustration even for defense as well. So
Yep. No,
what
I
is it?
understand that.
Yeah,
I understand. All I can say is this: the state at large, the Crown at large, is responsible for making sure all these prosecutions happen on schedule and happen in a smooth manner. So if a particular assistant Crown attorney comes in and says, "Look, I am sorry about this, Your Honor. This was just given to me recently.
yeah,
The other Crown can't do it anymore." I get a little bit, of empathy in that regard, and I'll try my best to be fair about it. But ultimately, if the accused person's ready to go and they say, look, today is my trial date or today is the date something is supposed to happen, then at least personally, I'm not going to give the state much slack in that regard. You've got to be ready. You've got to be on time, unless there's some bizarre exceptional circumstance, like the assigned crown came down with illness or something like that.
mhm,
But otherwise, no, it's just not acceptable. Like we've got to get past what I think in Jordan the Supreme Court called the culture of complacency. Well, what's the big deal? One more adjournment here or there. But it is a big deal. We've had many cases thrown out for delay in this jurisdiction, and in the Superior Court and in Toronto at least. We've got to do better. We've got to make sure that these matters are heard. For us, I appreciate it's disappointing that perhaps you might call it another day at our jobs, but there are real people's lives tied up in these cases, people who want to move on. I have no doubt that the accused parties want to have an answer as quickly as possible so they can either accept what's going to happen or at least put it behind them. But the witnesses and the victims and their families and everybody else, we can't just keep allowing them to sit out there and wait and wait. Well, we don't get our act together because we can't get things to work. So
yeah,
again, all I can say is, we're all responsible for this. Um, in particular, perhaps the state, because the state brings the prosecution, obviously, but counsel too. You've got to be in there and you should be ready. And if you're not going to be ready, then bring that adjournment application ahead of time. Bring it well in advance and say, look, I'm trying to get prepared for this. I foresee a problem. If you bring that adjournment application at least 30 days ahead of time, and hopefully even a bit more, if you can really see down the road and know there's a problem coming, that's different. Then I can see you're planning and you're concerned about wasting court time and you've given a lot of thought. That's different, but just kind of showing up the day of and saying, oh, I'm just so sorry, but it's been so difficult. Okay. But, fundamentally, is that really a basis to allow this to happen? Oftentimes not, right? So try to avoid it. Although I do appreciate the profession has become very demanding and I know there's a lot of stress on people. I do.
yeah,
Okay. Let me build on that just with something else. The seventh area I wanted to talk about. This is the importance of judicial pretrials. Okay, and what I said in my written materials here is what happens at a JPT matters. Okay, it really does matter. The point of these meetings with the judge, right, is to try to reduce the issues in a case to the minimum, to try to save court resources as much as possible, to try to talk out a case if possible, maybe to resolve it or to find an alternative, but really to make sure that we're not setting excessively long trials for no reason other than the fact that nobody really focused their minds to the reality of what the case would be about until too far down the road. So at the judicial pretrial, if an agreement is made or a concession is made by either side, right, it is expected to be honored. And if you show up at the day of the trial and then you try to deviate from something that was agreed to at the judicial pretrial, that's not going to go well. Okay. Some trial judges won't try to force an agreement on you at the judicial pretrial, especially not defense counsel. The counter argument is you're going to prejudice my defense now. I didn't think this through properly or whatever. Okay. But it's going to be embarrassing and it's going to result in delay. I highly encourage people to come into those judicial pretrials really prepared. Go through the disclosure that you've got at that stage. I know you may not have it all, but go through what you've got. Think through carefully what position you want to advocate for. If you're the Crown, please have taken a close look. Do you really have RPC? Have you asked the police to ensure, maybe that the witnesses can be located or they're on site or not? Have you given some serious thought to what might be a fair resolution or whatever? Because you can really get excellent value out of the judicial pretrial process. We all can if we use it properly. But if it's treated just like some sort of bump in the road that you just have to get over and then whatever, I'll focus on this more carefully when we actually get close to the trial date. That's going to be a waste of time, which is really unfortunate because I think a lot can happen at these judicial pretrials. And there's a great path there for good advocacy too. I've done a few recently, and I want to give credit to some younger defense lawyers in particular who come to those judicial pretrials ready to set a trial date if necessary, but will also send to the court ahead of time. And I will read all of this, a brief summary of what you're hoping to achieve, maybe at a resolution, documents demonstrating your client is engaged in counseling or something else if you're hoping to move it in a resolution direction, and maybe you're trying to see, what you can convince the judge to do. That really is impressive because I'll know ahead of time. You've already been working on this. You're already thinking it through. You've started to prepare materials. And this is your chance to make a fabulous first impression, possibly on the judge who will decide it. It doesn't have to be the JPT judge, but it might be the JPT judge. If we get along well and I really like what I'm hearing and I'm impressed, I can take the plea later in court or whatever it is, and maybe we can work it out. Um, so just don't underestimate the opportunity at the judicial pretrial. I know in some cases there's nothing that can be worked out. Maybe this one has to go to trial. We're just going to try to get an estimate, move it along as quickly as possible. So be it. That's fine. But if you think it can work itself out, or if it's going to go to trial, but you can realistically narrow the issues with the Crown Attorney, um, please take it seriously. And please commit to things only that you really can commit to. Because if you put yourself down saying, yeah, I'm okay with this now, and then later it gets to trial and someone tries to backslide off that, it's frustrating and creates just an unnecessary set of problems. In particular, I realize this can happen if it's a different Crown at trial than did the judicial pretrial.
Mm-hmm.
Although I have had on occasion it be on the defense side where maybe a different lawyer from the firm has picked up the file.
Yeah.
And then that second lawyer, quite frankly, didn't maybe read the judicial pretrial notes, assuming they had them from their colleague, as carefully as they should have. That's all I wanted to say about it. It is a great opportunity with me. If you want to follow up judicial pretrial at any point, you can always request one through our office, whether it's to discuss resolution, whether it's to rediscuss the estimates for trial. That's fine. If we meet today and the trial's not for a year, and then you're getting close to the trial date, and you go, oh my goodness, something's changed. You could always come back and see me again. I'm not going to be the trial judge, at least not in Toronto. I'm happy to talk to you about the case again. And if we can continue to work on the issues or anything else, that's fine. That resource is always there. It's really just an email away to try to set it up.
But I do have a question about
Yeah.
JPTs. Especially in the OCJ, they do happen very early on in the process. And sometimes we don't have
Mm-hmm.
enough time to really study the case and to really know or foresee all
Mm-hmm.
the issues that will come up. Sometimes some important
Yes.
issues that start to appear, even sometimes some charter issues that we were not aware of at the beginning, but we
Yes.
realize them after the JPT. So that could sometimes be problematic because then sometimes the Crown will say, well, I mean, why didn't you raise this up at the JPT? And the answer is simply, well, I didn't see this
Yes.
issue back then. So
Yes.
how do we deal with that type of situation?
Okay. So in my view, that's entirely understandable, first of all. I salute any Crown who's got all the disclosure available for the first JPT
Yeah.
and everything hypothetically can be worked out right away. I know that's not going to happen a lot, unfortunately. So the answer to that is to ask for a follow-up JPT. And I
Mhm.
hope that my colleagues are available for this. I think we all are, in Toronto at least. And then we'll be able to meet with you again when you've got more of the disclosure, ready to have more discussions. And then we can set further dates or we can refine the issues. Or if there's now a new motion or something that's going to come up,
Yeah.
that's fine. What I would discourage is this. You get the material later. Maybe it's been many months since the judicial pretrial. You want to bring the charter application, as you should. That's fine. You're entitled to do so on behalf of your client. And then you just kind of file the paperwork without having that follow-up JPT. And the problem with that is that it may completely affect the time estimates for the trial, right? And then it may be that you get to the trial and the judge at the trial says, well, I appreciate that the other judge authorized, say, a 2-day trial for this, but I don't see anything on here about a Section 8 application or whatever it is. And then you say, reasonably, Well, I didn't have all the disclosure materials at first, but now I've decided to bring it. Okay, fine. But of course, the time estimates are off, and now the trial may have to be broken up. It may not get done in 2 days. We have to get 2 days here and a day later or whatever it is. That can just be frustrating, right? So I highly encourage people, go back, make that request, just send the email to the Crown and copy the trial coordinator. At least that's how we do it in Toronto. Could I please have a follow-up judicial pretrial with Justice Jones about this case? Matters have shifted. We'd like to, discuss timing and everything else. These are very easy to set up. Many of us, including me, can make them happen any morning almost or after standard court time. I do most of mine by Zoom. I'm happy to accommodate people. And as a result of that, we can discuss this and we can look at the estimates. The worst case scenario is we meet for 10 minutes and we don't really have anything else to discuss. Maybe things can't be changed. Okay, we tried, right? The best case scenario is we catch a problem early and it helps save resources down the road and just make sure that things don't kind of get broken up or fall apart. Like, for example, if you needed an extra day, maybe the judge who's assigned isn't available for an extra day, but maybe another judge is, and the trial coordinator just shifts things around a little, and you still get the fastest trial you can as quickly as possible with the least amount of disruption to your client's life.
Hmm.
The other thing I would mention too, and I think this builds on something we talked about earlier, is if you feel you're having difficulty having productive discussions with the assigned Crown attorney,
Yeah.
um, come to the JPT. You don't have to get mad at each other, but just say, look, Your Honor, we've tried to resolve this. We don't seem to be able to come to something. Yeah, not a joint position, certainly, but not even really, what I'm comfortable with on an open position level yet. And we can have a talk about it. That's the point of the JPT. I won't be the trial judge. And you can tell me everything about your client you want to tell me. You can tell me what you're hoping to achieve. I can hear from the Crown. In some respects, the Crown, has jurisdiction over what charges may be part of the resolution or not. I can make suggestions. I can't necessarily force anything. We can have a very frank and open discussion about it, again, with no prejudice to your client, because I will not be the trial judge. The trial judge will never know about that discussion.
Yeah.
And if you just don't feel you're getting anywhere with the Crown, hey, there's no harm in trying something different. Go see a judge, have a discussion with the judge. Maybe things can shift again there. Maybe you can make some progress in that regard.
Thank you. And our last tip for the
Okay.
day.
Now this one's important. We're going to end on this one. Okay. Okay. Just what I'm calling some caution about virtual appearances. During the pandemic, virtual appearances, I appreciate, were everything, and they still are for case management courts, for many guilty plea courts, obviously for judicial pretrials, at least how I do them, etc. I'm a big fan of maximizing virtual appearances where they're appropriate. Okay, I understand in particular for defense counsel, it can be costly and difficult to travel to different courthouses all the time. In my view, it helps enhance access to justice for many people who may not be able to afford, to pay people to go to multiple courtrooms for themselves in person. Or maybe you're just, the parent of a young person charged with shoplifting, far distance from the courthouse, coming all the way down to the courthouse to make a simple appearance means the kid's going to lose a whole day of school or something. A simple Zoom appearance instead can minimize that disruption dramatically. Let's take advantage of this. Let's make it work where it works. Okay, absolutely. But, okay, here's the but. Don't assume you can attend virtually for anything. Certainly not trials or preliminary hearings, but really anything. Check the current practice direction, both for the Ontario Court of Justice at large, but maybe something specific in your region or local courthouse. Ask around. The regional senior justice may have set certain rules or expectations, or maybe another policy in place. And if you are going to appear virtually and you believe it's permitted, or a judge has told you it's permitted, just please don't lose sight of the fact that it's still a court appearance. You should still come and act professionally. You should make sure, that the technology works, that we can hear you, that we can see you, you have a stable internet connection, etc. And if you have any persuasion with your client, make sure that the client understands that they should also come and act professionally,
And
and
dress
not
up.
just not even dress up, just dress. Don't
No,
dress
but
down.
actually have clothes
Yeah,
because I mean
have
we've
that'd be
seen
nice.
that.
Yes,
Yeah. Yeah.
don't have a Tim Hortons cup in your
Yeah.
hand. Please don't be calling from a moving car or something that just scares me very much. Um, there's a code of conduct for remote appearances for the Ontario Court of Justice on our website as well. I know other courts also have these types of codes of conduct. You know, we're not all so super strict about enforcing them, but they really should be followed, especially if you're a lawyer, obviously. And I know you have limited control over some of your clients, though they may or may not listen to you or take
Yeah.
the advice so seriously. But if remote court is done well, it can function just so impressively. But there's always this concern, that people don't take it as seriously as they should, and then we need to bring people back into the building as much as possible. I'm very sensitive, again, to the realities of what it's like to be a young lawyer starting out now, and the need to make sure that we accommodate people's needs and their personal lives and childcare issues, all those sorts of things that are very important. But at the same time, it's still a court appearance and it has to be taken seriously. And again, just don't assume ever that you can appear virtually or your client can or a witness can. You have to bring an application often for that, especially for a trial or a preliminary hearing. And it doesn't matter even if the other side agrees. The two of you may consent. Oh, that's fine. That's great. But it still takes the approval of the court, right? And it may often require a formal application. And at least in Toronto, while you can discuss these things at the judicial pretrial, oftentimes, because the trial judge will be different than the judge at the judicial pretrial, the JPT judge won't, agree in the sense that we're committing to anything. You're probably still going to have to bring an application if you want a witness or somebody to attend remotely, or if you personally would like to attend remotely at the trial for whatever reason. It can happen. I'm personally fine with letting it happen maybe more often. Some of my colleagues much prefer in person still. They want to go back to that. The presumption in the code, though, is in-person appearances. Okay, it's right in the criminal code, section 715.21. So if you want to deviate from that presumption in law, you really do need to make sure you bring the right application. And again, please, please, please don't do this. Don't bring an application and say, oh, I'm going to have Mrs. Thompson testify remotely on this day. You convince me that it's appropriate. And I go, okay, I grant the application. And then on the day, her internet doesn't work, or she's got her cat running across the screen the whole time she's testifying, right? And I know it's not you specifically that is responsible for that, but it's just very disappointing. And it will make me wonder, did you properly communicate to the witness the importance of how they have to be prepared to appear in a courtroom? It still is, even though you're doing it remotely. And I'll say the same thing to the Crown, too. If you have witnesses who want to appear remotely, you need to make sure, work with the police, work with victim services, whoever it is, they have a stable internet connection in a private space. Vitally important. There's no suggestion they're being influenced by somebody else while they're testifying. Either someone else is in the room with them, or maybe they have a handheld device and it looks like they're clicking, all the time here. And is someone sending them messages while they're testifying or what have you? All of this is just very unsettling and causes us to worry about the integrity of the proceedings.
Yes. Well, this was really very helpful. It's a very nice refresher, and also, tips just to remember, I mean, court practices, best practices, especially, well, not just for, I would say, not just for new lawyers, it's for all
Yes.
lawyers, because sometimes we just forget, and it's always very nice to start the year with all these reminders. So thank you so much, Your Honor, for taking the time to remind us about all these very important and useful tips, and I'm sure a lot of people will benefit from them. So thank you very, very much for your time today.
You're very welcome. Thank you for having me. And look, if you're a young lawyer, you're always welcome in my court. I'm happy to see you. I want to make it work. Let's just work together and do things well.
Thank you so much. And I'm sure many lawyers will appreciate that.
Great.